Welcome to SpringLaw's 2019 SpringForward Legal Updates Webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit SpringLaw at www.springlaw.ca. And now to our presenters.
Everybody.
Good morning, everyone, and welcome to the SpringForward Legal Updates monthly webinar series. I want to confirm that you can all see me, you can all hear me. Today is the 5th of our 2019 monthly webinars, and the topic is drug testing, what's the deal? My name is Oren Barbalat, and I'm joined by Hilary Page, my wonderful colleague. We're both lawyers at SpringLaw. If you're one of our clients, you probably know that we are employment and contract lawyers at our virtual law firm based out of Ontario. We specialize in all types of legal issues that arise in workplaces. If you're new to our law firm community, we welcome you. During the webinar, please feel free to ask questions through the chat function. If we can't get to your questions during the half hour, we'll be sure to reach out directly to you afterwards. Slides will be provided after the presentation, or you can download them right now under the Handouts tab in a PDF. Finally, for more information on our law firm, please feel free to visit our website at springlaw.ca, where we have a variety of resources there, including our award-winning weekly blog post, which Hilary delivers award-winning content to, a link to subscribe to our monthly newsletter, information about our innovative subscription program for employers, our Bill 47 ebook, and our ebook for employees recently fired and looking for an alternative to in-person legal services. Okay, let's jump in. So I'll just start off with a brief presentation roadmap. Hilary's going to kick it off with some general principles about drug testing. She'll also go over the laws covering impairment at work. I'll briefly discuss safety sensitivity and why it's so important. Hilary will then chat about targeted drug testing with respect to specific employees and random drug testing. I'll touch base on human rights issues. Then I'll hand it over to Hilary to chat about off-duty drug use. And then I'll go over policies, and we'll have some great takeaways for you at the end. Over to Hilary for general principles.
Yeah, so welcome everybody. Thanks for joining us. So just some general principles regarding drug testing. Employers do have the right to expect that employees arrive fit for duty and remain fit for duty during their workday. So generally, there's sort of a blanket expectation that an employee cannot be impaired at work. How that dovetails with drug testing, we'll talk about. But you know, the basic sort of stance in Canada is that you cannot randomly drug test employees without a really good reason. And there are some privacy and human rights reasons for that. Employers do have a duty under the Occupational Health and Safety Act to keep their workers safe from hazards, and those include those resulting from impairment. But how to do that while balancing privacy and human rights is something we're going to talk about. So, impairment at work. Here's just the relevant principles from the Occupational Health and Safety Act and the Highway Traffic Act. So, employers and employees have duties under the Occupational Health and Safety Act regarding safety. So, employers have the duty to take every precaution reasonable in the circumstances for the protection of the worker. In some situations, that might involve drug testing. We'll talk about that. And workers, this is sort of building on what I mentioned before, workers have a duty to basically work safe and not endanger anyone. So generally that's going to require that they be sober. And then for jobs that specifically involve driving, and this is relevant to cannabis, which, as we all know, is now legal recreationally in Canada, the Highway Traffic Act actually prohibits drivers with the A to F class license from having any cannabis in their system. And as we know, having cannabis in your system is not necessarily an indicator of impairment. So that's a pretty big deal, having no cannabis in your system. And the Highway Traffic Act also prohibits drivers driving under the impairment of alcohol or drugs, which is not surprising. So I'll turn it over to Oren to chat about safety sensitivity and how this fits in with drug testing.
Thanks, Hilary. So safety sensitivity it's really the starting point for any drug testing program. And it's absolutely critical that if you're considering instituting a drug testing policy, if you have one in place, it's absolutely necessary that there be a safety sensitive issue. And so, Hilary touched on privacy. I'm going to be touching on human rights shortly. Those are additional considerations, but again, at a base level, there must be a safety issue if you're considering any kind of drug testing program. And when you're looking at safety sensitivity, you're looking at both the position and the industry. And so our courts have considered this. This has come up in several cases. So certain positions at mining, construction, hydro, oil extrusion sites, those would be the positions that would be safety sensitive. And then, the industries, which would be safety sensitive. And then positions involving the operation of heavy machinery or transportation of passengers. So again, you're looking at the job and you're looking at the industry. So a TTC operator, for example, that's arguably a safety sensitive industry, but the position itself, right? There are many lives at risk. Obviously you would want, hopefully your TTC operator to not be inebriated. So that would be a safety sensitive position, whereas, a mining facility, which is a safety sensitive site, maybe not every role at that mining facility would be safety sensitive. So again, you really do need to consider both the position and the industry. And I'll hand it over to Hilary to chat about targeted drug testing.
Yeah, so as Oren said, safety sensitivity is really the starting point when we talk about drug testing. Without safety sensitivity, either in the position or the workplace as a whole, or I guess just basically in the position, that person who we're considering drug testing must hold a safety sensitive position in order for us to sort of jump over these legal hurdles that would allow drug testing of this employee. So drug testing targeting a specific employee, which is different from saying, we as a workplace now randomly test for drugs every month, everybody. That would be, a blanket policy that's different from this targeted drug testing we're talking about right now. But a targeted test would generally be permissible if the employee holds a safety-sensitive position. So let's say they're a TTC bus driver. If they work for the TTC, but they are a file clerk, they're in a safety-sensitive industry, but they don't hold a safety-sensitive position, that's not going to be justifiable. But if they're a driver of some sort, operating heavy machinery of some sort, that's a safety-sensitive position. And a specific circumstance exists. So the specific circumstance, obviously that can be many things, but there needs to be a pretty good reason why the employer feels that the safety at work is at risk, and this person specifically needs to be checked out. So that could be suspicion of the employee being impaired. Maybe they smell like alcohol, or they smell like cannabis, or someone sees them doing a line of coke in the bathroom, something like that. So a suspicion that's got some decent evidence, more than just like, oh, I hear that guy's a pothead. And And then it can also be aroused by a specific incident in the workplace. So this is sort of obviously we don't want incidents, but if there is an incident, that's going to justify that testing. So some sort of accident or near miss that could be explained by user error and user impairment. That's gonna justify targeting a specific employee. Otherwise, you can't just test that guy who you think is a pothead without those specific circumstances existing and without the position being truly safety sensitive. So random testing, as I mentioned, this is where you sort of blanketly test everyone in a safety sensitive position. And this is a higher bar, obviously, because it's imposing something on the whole workplace, potentially, in those safety sensitive positions, not on the administrators necessarily. Unions are going to generally have trouble with this. So, and often these workplaces are unionized. So, just to be aware of that. But again, like I was saying with the individual case, you need the safety sensitive position as well as a reason to do the testing. So, and it needs to be evidence of sort of a general problem and general safety risk. So, maybe a bunch of your employees have just been convicted for drug dealing in the workplace or something like that. That's going to be an evidence of a general problem. If it's just one or two employees, that's not a general problem. And again, you're going to need those specific circumstances like the evidence and then maybe something's happened, right? I should just mention that regarding the targeted drug testing, so if it's just a specific person that we're looking at, and I think Oren will follow up on this, but if an individual is returning from work following substance abuse treatment or something like that, so that would be something that would constitute a specific circumstance. We know they've had a problem in the past. We need to make sure that they're sober going forward. That may justify specific targeted testing on an ongoing way, but just having a couple employees falling into that bucket is not going to justify testing just randomly the entire safety sensitive workforce. So, I think I covered all the bases there. Anything to add to that, Oren, at all?
No, I think that's fairly comprehensive, and it's a good lead into our next topic, which is human rights issues. So random drug testing and targeted drug testing are, it's a good overview because those primarily deal with privacy issues, right? But that's not the only issue that's engaged when you're considering something fairly intrusive like testing someone for drugs or alcohol at work, right? And so we have a lot of human rights legislation in Canada. In Ontario, we have the Ontario Human Rights Code, which applies to provincially regulated industries. And in Canada, or in Ontario as well, we also have the Canadian Human Rights Act, which applies to federally regulated industries. And human rights legislation essentially protects people who suffer from a present, past, or perceived addiction to drugs or alcohol, right? So that's when the Human Rights Code gets engaged, is when someone is using as a result of an addiction, which would be a disability as defined. And then under the Ontario Human Rights Code, employers are required to accommodate employees with disabilities. And this issue kind of came up in a really big and landmark decision in Entrop, which was a Court of Appeal decision. And that case kind of laid out the circumstances where it would be appropriate to have a random drug testing policy in that instance, and really the hurdles that you have to overcome to have an effective policy. And it really also demonstrates that the policy on its own doesn't end the inquiry, right? There's still other obligations. So in Entrop, what essentially happened was, in the wake of the Exxon Valdez catastrophe, an oil company started instituting a variety of drug testing policies at their workplace. And they were random drug tests. And so one employee who had previously tested positive was now subjected to a random test, and he was disciplined, and he took issue with that test. And so what the Court of Appeals said was that, first of all, if you have a random drug testing policy and everybody who tests positive is penalized, on its face, that's discriminatory, right? Because you're potentially treating people the same who may not be the same. So someone could test positive because they like to have a lot of fun on the weekend, or it could be that they have a legitimate addiction issue, and that's a disability. So again, any kind of policy that automatically disciplines somebody as a result of a positive test will be discriminatory. However, what the Court of Appeal was looking at, can the policy still be justified? And what are the circumstances where it can be so? And so on the slide, you see the three criteria here. It is a legal test, and I'm sure you can all read it, but essentially the test is it rationally connected to the performance of the job, right? And this is where safety sensitivity comes into play, right? Which is why, again, it's so important for any employer contemplating something as intrusive and as invasive as a drug testing policy, that you really tie in the safety sensitivity to the performance of the job. In this case, working on an oil refinery with limited supervision, it was proven to be rationally connected. Number two, was it adopted in good faith? So here, the policy can't be for moral issues. It can't be that you want to make sure that your employees aren't, recreationally consuming cannabis on the weekend or getting drunk on the weekend. Is the policy adopted for the specific purpose that you outlined, which should be to make the workplace more safe? And then number three, is the policy reasonably necessary to the accomplishment of the legitimate work-related purpose? And here what you're looking at is there maybe a less intrusive way of accomplishing that goal, right? If the goal really is to make the workplace more sensitive or more safety sensitive, could you do that through education? Could you do it through coaching? Or is drug testing somebody really the most effective way of doing it? So in Entrop, it was found to be legitimate because in that case, again, there was minimal supervision, it was highly safety sensitive, and the type of testing was a breathalyzer, right? Which at that point in time had already been proven to be a reliable way of measuring impairment. But what's important to note is the court said that, okay, on its face, your policy is discriminatory. We're going to say it's okay in these circumstances, but the inquiry doesn't end there, because we need to see, how far does your policy go? So even though you can test somebody, you're not necessarily permitted to terminate them just because of a positive test, right? So the Ontario Human Rights Code and our human rights laws, they require accommodation. This is something we blog about frequently. We did a webinar in April on this, which hopefully should be downloadable soon. But really, for our purposes here, there's still accommodation responsibilities if someone does test positive. I know there's a lot of questions about pre-employment and whether testing is permitted pre-employment. The Ontario Human Rights Commission has commented on that. They're not fans of it, and the reason for that is when you're testing someone prior to employment, it's difficult to connect the impairment to the essential requirements of the job, right? So if I go and test today and it shows that I was impaired sometime in the past, that doesn't necessarily prove that I won't be able to perform my duties on the job in the future. And again, even if you do have a policy, it engages the accommodation issues. Now, with respect to cannabis, this is obviously going to be a hot topic because your employees are permitted to recreationally consume cannabis, but as Hilary mentioned, they still must be fit for duty, right? They still have to perform their job. You as the employer, you still have your requirements to maintain a safe workplace. So with medical cannabis, the laws really, in terms of managing your workplace, are the same. So for medicinal cannabis, require documentation, and the documentation should explain why the consumption of cannabis is required at work. And accommodation does not mean that the worker can come to work impaired necessarily, right? That's not what accommodation is. For someone with an addiction to cannabis or alcohol, it could mean, as Hilary alluded to earlier, that you accommodate some time off, right? So again, when you're considering drug testing and human rights issues, look at the policy. Does the policy automatically penalize someone for positive tests? And then if it does, what are you doing with those positive results, and how are you integrating people back into the workplace? And now I'll hand it over to Hilary to talk about another hot topic, which is off-duty drug use.
Mm-hmm. Yeah, so off-duty use is something we got some questions about with the legalization of cannabis, just because employers are wondering, can I just tell my employees, if you want to work for me, you can't use cannabis at all? And the way we can think about cannabis is a lot like the way that we've been thinking for years about alcohol, right? So we don't let our employees, drink at work, usually, at least not before Friday afternoon. And similarly, we would expect that they do not use cannabis at work. But we wouldn't go so far as to say, if you want to work for me, you can't drink, right? So similarly, the employer shouldn't be making that kind of blanket policy about cannabis or other legal drugs. Illegal drugs are illegal. So, if your employee is using those, they're breaking the law, and I don't think it's really something you need to mention in terms of prohibiting it specifically, right? So we have seen some safety-sensitive workplaces prohibiting off-duty cannabis use. So we've seen this with some police forces, I believe the armed forces, some airline pilots, maybe firefighters, so things like that, but they're prohibiting them in a limited way, so within limited time frames. So something like, you can't use cannabis 48 hours before the start of your shift, something like that. As we know, there's no reliable test for current impairment of cannabis, and cannabis is going to stay in different people's systems differently. So in terms of enforcing a rule against some sort of off-duty use, it's going to be really tricky because of all those reasons why drug testing isn't really just allowed, and also because the testing is likely going to be pretty inconclusive. If someone tests positive, they have THC in their system, that doesn't necessarily mean that they've broken that workplace rule that would say you can't come to work if you've consumed cannabis within the last 48 hours. So, as I said, generally employers should not be interfering in the personal lives of employees, but there can be some limited circumstances where it's rationally connected, where it might make sense. Just to be extra cautious about that impairment in those safety-sensitive situations where where it's all rationally connected. So that's off-duty use. Oren's just going to touch now quickly on policies and how you can design policies to deal with impairment and drugs in the workplace.
Yeah, thanks, Hilary. And so the overarching theme here obviously is that if you want a drug testing policy, it's a fairly intrusive measure, but that doesn't mean that you can't have policies about the use of drugs in the workplace or the use of alcohol in the workplace. And it's important to be clear about those and to set clear expectations. And so it is important, again, to train management on detecting impairment. What does that look like? And in tying in whatever the policy is, tying it into the performance of the job, right? as opposed to the moral judgments. And so we have a line here, the prohibition era is over. It is, but again, your employees still need to be fit for duty. Just because they can get high on the weekend, it doesn't mean that they can get high on their lunch break and then go to Chipotle and come back to work totally unfit for duty. So having those clear expectations, putting them in writing, it's always a best practice. And then to take it a step further, you could also be clear about what your accommodation policies are, right? And it's really doing your due diligence and really making sure that if you do have a policy that is explicit about the use of drugs at work or the use of alcohol at work or impairment at work, then explain to employees if they do have a problem, this is the process for disclosing it, this is our process for accommodating it, just so you're making sure you're complying with all your duties to comply with human rights legislation and at the same time maintain a safe workplace. And again, documentation is key. So if you have your clear policies about the use of drugs or alcohol and those aren't being abided by, have a system for documenting that. And progressive discipline, this is something we talk about often, that if you do eventually want to terminate someone's employment for cause because of misconduct, and if you want to relate that misconduct to constantly coming into work inebriated or unfit for duty, you absolutely must document that and have a good record of the incidences as they arise. So now I'll hand it over to Hilary for key takeaways.
So, just as Oren said, it's a good idea to set clear expectations through policies and training. So, as you just mentioned, Oren, if you have a policy that deals with, if you have a drug problem, this is what we want you to do so we can accommodate you and help you deal with it. That's a good practice, and that can, if the employee doesn't comply with that, that's not necessarily discriminatory. That's just a workplace rule they didn't comply with. So that's an important thing to set up. Be prepared to identify and address impairment. So this can be tricky, but have your managers on the lookout for issues. What does impairment look like? Be aware of when those situations that might lead to a reasonable belief that there's a problem arise. Understanding the employer's duty to accommodate is important, and this is with respect to medical cannabis, as we discussed, as well as any addiction, and this could be to any drug or alcohol. These are considered disabilities under the human rights legal system, and they are disabilities that the employer needs to accommodate. So even if someone has a safety-sensitive position, and they absolutely must be sober to work in that position, if they come to you and say, I have a alcohol dependency or a cannabis dependency, that doesn't necessarily mean that they lose their job. They just need to be accommodated with help from the employer to get well and see if they can do that job going forward. Invade your employees' privacy at your own risk. So employers do have a limited ability to control employees' off-duty behavior, and also limited ability to conduct those random drug tests. So what your employee does on their time off is not really any of your business, unless you can somehow rationally connect it to needing them to be fit for duty. So, and that's where we would see those time limits and that sort of thing come in. And those are the takeaways. So 2 minutes to go. Do we have any questions? I guess not. Do you want to tell them about our upcoming webinar, Oren?
Sure. Well, thanks for joining us, by the way, for our SpringForward Legal Update. We do hope that you'll join us for our next session on September 18th, where we will be chatting about recruitment, AI, and human judgment. It's something we love blogging about and presenting about, so I do hope you tune in. If you have any questions about today, anything discussed, please feel free to follow up with me or Hilary or any of our lawyers. Please check out all of our workplace law resources mentioned at the beginning of the webinar, which are all on our website. Feel free to follow us on Facebook, Twitter, LinkedIn, and Instagram, and sign up for our monthly newsletter to stay up to date. Thanks again for joining us today, and have a great day. Bye-bye.
Thank you.